which is called IPA, Intellectual Property Appellate Board, IPAB. You can file an appeal there. If you are not happy with the appellate board's decision, then the jurisdiction lies in the High Court. Then you will have to contact Mr. Chaturvedi. You'll have to come to me to challenge that IPAB's decision against you in the High Court. And that is where the litigation part begins. That is where I said that those lawyers who want to be arguing counsels or litigator side, you have a future there. You can be an IPR lawyer. Now these are conventional intellectual properties. As I said, in the year 1999, one more area was carved out called geographical indicators. Now what is this geographical indicators? Geographical Indicators Act of 1999 says that an association of producers or a body of producers of a product can get themselves registered and can get the product registered on the basis of a geographical dimension. The product itself is known with the geography. For example, Bikaneri bhujia. Now that bhujia, that type of product, that type of namkeen originates from Bikaner, so Bikaneri bhujia. Dehraduni chawal. The chawal, the rice produced from Dehradun, geographical area. You are identifying the very product from a geographical area. That is registered under Geographical Indications Act of 1999. You want the product of a particular geography. So you go and demand from the shopkeeper that I want this product from this geographical area. There is a kind of wheat, Gehu, MP Sihor Gehu. This is geographical indication. Now you may be getting wheat of various kind, produced several parts of India, but you want a particular geographical area's product, and that is why it is being registered under Geographical Indications Act of 1999, which is commonly known as GI Act. You have to register your product under that GI Act. And therefore that cultivation, that product belongs to that area. For cosmetic products, people use Multani mitti. That comes from Multan, geographical area. So Multani mitti I want. That is how these geographical areas have their own product. And the value of the product is basically from that geography, geographical area. The product may be available from different areas, but you want the product of a different geographical area. That is why the Geographical Indications Act, a separate carved out, new enactment. Thereafter, as I explained, in the year 2000, 3 more statutes were introduced. First was Biodiversity Act of 2000. Now this was the result of another UN convention which is known as UNCED, United Nations Convention of Environmental Development, UNCED. Post this convention, a need was felt for protection of flora and fauna of the world. Now there are several advertisements you must have seen: Bengal tiger, Gir lion. Now this lion is different from an African lion. Now that species has to be protected. Certain plants are dying, certain forests are dying, that flora and fauna need to be protected because that is the identity of that particular area. It doesn't happen any other place other than that area. So for the protection of the flora and fauna, a new act under the Environment Convention was created, Biodiversity Act of 2000. And that is a property of that area. There were a special species from the state of Madhya Pradesh which was known as white tiger. This white tiger is not found anywhere in the world. And you would be surprised that if you visit any country globally where in a zoo you find a white tiger, you will be surprised to note that it is being supplied from a state called Madhya Pradesh, part of India. They will have to demonstrate that signboard because it is the species from India and registered under Biodiversity Act of 2000. So they cannot circumvent the declaration. Then another act which was created was Plants Variety and Farmers Act. This was for the cultivation of new products by the combination of agriculture and horticultural researches. Now you might have observed that there are bonsai mango trees. The plant is very small. The height of the tree may be equivalent to you, and still there are mangoes. Already the product is there. Unlike those huge trees, now these are bonsai trees. These are cultivated, developed by farmers. By breeding different types of plants and varieties. There are agriculture universities in India. There are agricultural graduates, soil scientists who research how to create new species, new types of fruits, new combination of vegetables, how to multiply the production. Now these researches need to be secured because this is a property, an intellectual property. And if this process of developing this new product needs to be protected because somebody has put a lot of effort, hard work to cultivate this plant, which without totally being grown up started producing the fruits. So that comes under the Specialized Act of Plant Variety and Farmers Act. Then there is Integrated Circuit Plant Design, Layout Design Act. Integrated Circuit Layout Design Act is, you might have seen in computers or in these televisions or most of these electronic devices, there is a plate which is having multiple chips. There is an integrated circuits, very minute circuit is being created. If you have ever seen a motherboard of a computer, that motherboard is a very, very technically integrated, that silver linings in that chip. Now, these are created after a lot of research and hard work. And that is why they are called integrated circuit. Every integrated circuit has a different layout plan. And that is why in your computers, every year you see the processor has enhanced the speed. So to enhance that speed, this whole process, integrated circuit, has to be cultivated more and more and more. Now the design keeps changing. So whoever is applying the mind has to be rewarded because that becomes his property. And it need not to be copied by the other who simply copied and started utilizing and exploiting that property. And therefore, the Specialized Act, Sui Generis Act, was created, called Integrated Circuit Layout Design Act. And there's one more act called Design Act of 2000. The Design Act of 2000 is where you create by your fertile mind, you create a design. Now this design is called article. Now under Design Act, a very interesting facet which you must remember is that the design must be visible to the eye. If you want to register your design, the design must be visible to the eye. Like for example, if you want to have, if your fertile mind created a pen stand in the shape of Statue of Liberty, where the Statue of Liberty, instead of holding that flames, is holding the pen. Now this is your innovation. This is called design. So you created a pen stand in the shape of Statue of Liberty. Or you created a water bottle in the shape of Qutub Minar. This is your design. But the design must be visible to the eye. That article, that shape is your innovation. It's your property, which you conceptualize, you put an idea, you innovated, and you made it that some particular routine activity in a very dull form was available, but you created with your innovation a beautiful article out of it. That article, that design which you create, you can register under Design Act of 2000. And you can become, for a particular period, the owner of that design. Nobody can copy it. And if somebody is trying to copy, he has to either take license from you and pay royalty to you. So these designs, which are called articles, can also be created and registered. So these are various intellectual property statutes which we have in India as on today. Although I admit that this is, each act itself, each statute itself needs to be a subject matter of a detailed study and advanced level studies, the practical applications, because there are people who are earning their bread and butter out of one particular act as a professional dealing in that area. But as the whole intellectual property and overview, this is what the historical background, the statutory provisions, the law of the land, and some of the international treaties which I mentioned, they are all covered under intellectual property rights. I hope that some of you as future lawyers may choose intellectual property as the area of your profession. And mind you, intellectual property is the future property of the world. Gone are the days that in future the movable area of intellectual property is live. Thank you so much.
Thank you, sir, for